So guys, let's begin from the beginning once again. A very good evening to all of you friends. Welcome to BYJU'S Exam Prep, the most comprehensive preparation app for all exams. In this session, I shall be discussing with you, or rather talking to you, about some of the most important legal developments that took place in the month of May 2023. So those of you who are preparing for CLAT, ALIT, Symbiosis, Maharashtra CT and other host of examination, this session will give you an insight out of what happened in the legal sphere in the month of May 2023. But before we begin, BYJU'S Exam Prep brings to you a CLAT 2024 comprehensive course. Secure a seat at your dream NLU. In this course, we shall be providing you with 300 plus recorded videos across 5 sections, 300 hours of live classes, 35 mock tests for CLAT and other law exam along with video solutions, monthly e-magazine for current affairs, and the entire content is based on our extensive analysis of the last 5 years of the CLAT question paper. Our BYJU'S Exam Prep also brings to you unlock 3-day free trial access to all our courses. Link is given in the description box below. Just enter your valid phone number and you get access to all our courses free of cost, but just for 3 days. BYJU'S Exam Prep brings to you CLAT 2024 Essentials. What to study and what to skip. This will be an interactive free workshop happening on the 18th of June at 6 p.m. by Nivedita Madam. So, what happened in the month of May 2023? The real important developments that happened in the legal field in the month of May 2023. Now, there are certain judgments which are absolutely important. These are all constitution-based judgment. I'm sure most of you are aware of it. The first one was Shilpa Sailesh versus Varun Srinivasan. This is a landmark judgment which deals with the power of the Supreme Court under Article 142 of the Indian Constitution, whether the Supreme Court has the power to dissolve a marriage under Article 142. Now, 142 of the Supreme Court gives the power to the Supreme Court to do complete justice. Now, in case there is injustice that the Supreme Court sees, it can invoke its 142 jurisdiction to cure a wrong that has taken place. So, more on this particular judgment in the later slides. But moving on, next important judgment is the government of NCT versus Union of India, whether the Arvind Kejriwal versus a Modi government, the tussle between the control over the services. Now, the Supreme Court by a 5-judge judgment held that other than land, police and law and order, other than land, police, public order, everything will be under the control of the state elected government. So the state legislature, the NCT, okay, the Arvind Kejriwal government will have all the powers relating to everything other than land, police and public order. Only these things will be under the control of the central government. So I'll come to what the Supreme Court had to say on that. Thereafter, we also had the Supreme Court by a 5-judge bench judgment upheld the practice of Jallikattu. Now, what is this Jallikattu? What is this sport of animal called Jallikattu, which is, celebrated across Tamil Nadu? So we'll come to that judgment. Also, what did the Supreme Court say? What is the importance? Now, important judgments will help you because you don't know, you might get a particular passage in your examination from these judgments. Now, if you have an idea about these judgments, it helps you. Apart from that, another very important legal development, a new law minister. And who is he? Arjun Ram Meghwal. Arjun Ram Meghwal has been appointed as the Union Law Minister of India. He replaces Mr. Kiran Rijiju, who was the earlier law minister. But as on today, the law minister of India happens to be Mr. Arjun Ram Meghwal. Very, very important. So these were the important developments. But let's understand the first, let's take the first case. Okay, the judgment of the Supreme Court, which dealt with the power of the Supreme Court under Article 142 of the Constitution to dissolve a marriage. Now, marriage is an institution where the importance of the child, the importance of the family, everyone's importance is to be taken into consideration. Now, under the Hindu Marriage Act, there are certain provisions relating to divorce, okay? Cruelty, there are various grounds, right? Adultery, various grounds. Now, one very important thing that we have to understand over here is the fact that the Supreme Court, whether it has its power under Article 142 of the Indian Constitution to dissolve a marriage. Now, if the marriage has more or less broken, if a marriage between two individuals have more or less broken, now, will it be possible, for the courts or on technical grounds or for any other purpose, keep that marriage going and going and going? The Supreme Court says no. If there is irretrievable breakdown of marriage, that means, both the parties are not in a position to stay together. It is good, even if, because generally the law says that only family courts can grant divorce. Only family courts. The High Court, the Supreme Court, on an appeal they can, but they cannot come. Now, the Supreme Court says, yes, it is very important that there are certain marriages which has more or less broken down just because of court orders. They are still surviving, but it is of no good use. The Supreme Court says that we have had that it is possible for this court to dissolve marriage on the ground of irretrievable breakdown of marriage that will not contravene any specific or fundamental principles of public policy. The Supreme Court further adds that this court, in exercise of its power under Article 142 of the Indian Constitution, has the discretion to dissolve the marriage on the ground of irretrievable breakdown of marriage. This discretionary power is to be exercised to do complete justice to the parties, wherein this court is satisfied that the facts show that the marriage has completely failed. Now, so if it is shown to the court that the marriage has absolutely failed, has completely broken down, then the power under 142 of the Constitution can be interpreted in such a way that the Supreme Court has the power to grant divorce. Am I clear, everyone? But this is a discretionary power. Now, the court has to be satisfied that, the marriage has broken. You have to show those evidences to the court. And there is no possibility. What does the Supreme Court say over here? There is no possibility that the parties will cohabit together and continue. A formal legal relationship is unjustified. The court, as a court of equity, is required to balance the circumstances and the backgrounds in which the party opposing to the dissolution is placed. So, the court has to take a holistic view of a situation wherein the court, if it is satisfied that, the marriage has broken or something like that, it can grant divorce. The Supreme Court finally said, this court should be fully convinced and satisfied that the marriage is totally unworkable. emotionally dead and beyond salvation, and therefore dissolution of marriage is the right solution and the only way forward. So the court has to be satisfied that the marriage has completely broken, and only then the Supreme Court can grant the relief of a divorce. Am I clear? Am I clear, everyone? Very important judgment, guys. Very, very important judgment, I must say. Okay, very important judgment. Okay, okay, okay. The next important judgment is the government of NCT versus Union of India. Now, this is a very big debate that is going on whether Delhi is a state, it's a union territory, and the constitution has kept it in a limbo. Now, why do I say that? Because Delhi has an elected government, people vote. Now, unlike other union territories, Chandigarh, so the power is with the union government, most of all the powers. But whereas in Delhi, an unusual situation, because Delhi has a legislature. Delhi has its own legislature. Since Delhi has a legislature, now the constitution says that other than land, police, and public order, the state legislature will have the power to make laws on all the subjects. Other than, now West Bengal government can make rules, laws relating to land, service and public order also, but the Delhi government cannot. That's a constitutional bar. That's a Lakshman Rekha. Now, what has happened is some very disturbing fact. The fact is that the government of India, by a notification, says that this Delhi government will not have the power to appoint services. Now, what is this services? Let me say. The secretaries. Now the ministers are appointed. Now who is the executive? The secretaries, the IS officers, the cadre officers, and all. Now who is appointing them? The government of India. Now if the Delhi minister is saying something that please do something, the secretary of that department will say no, I'm not going to do. I will take orders from the government of India. Now that was a tussle that was more or less happening in Delhi. Now, unfortunately, Delhi is today governed by parties who are opposite to each other. One is the Kejriwal government, the central is by the Modi government. So, the constitution simply says other than land, police, public order. Everything the Arvind Kejriwal government does. Now, in a federal constitution, certain powers exist with the government of India. Similarly, certain powers do exist with the state government. Now, the 7th schedule, there are 3 lists. List 1, list 2, list 3. List 1 is the union list. Only the union parliament shall have the power to make laws insofar as this list is concerned. You have list 2. Only the state legislature shall have the power to make laws relating those entire entries in those lists. Similarly, you have a concurrent list when both the union parliament as well as the state legislature has the power to make laws. But the constitution also very clearly states that in case there is a confrontation between a state law and a central law relating to the concurrent list, the law made by the parliament shall prevail. Okay. Now, in Delhi, an elected government is there, but more or less the central government was controlling everything. Now, there is also this question about the governor's role in this under our Indian constitution, the role of governors. Now that is again a very debatable topic. Let's not get into that. Now there was this tussle. So Arvind Kejriwal government went to the Supreme Court, and a 5-judge bench of the Supreme Court said that, look, state government will have powers on all subjects except police, land, and public order. Other than that, only these three, the union government can, can tinker. But others, the state assembly will have the power. What the Supreme Court says that thus, in a federal constitution, at a minimum, there is a dual polity. Two sets of government operate. One at the level of the national government and the second at the level of the regional federal units. So you have union as well as you have various states. These dual state of government elected by we the people in two separate electoral process are a dual manifestation of public will. The priorities of these two sets of government which manifest in a federal system are not just bound to be different but are intended to be different. So there will be two, the makers of the constitution understood that there will be two sets of government. They understood, and that's the beauty of our constitution. The executive power of the union in a state over matters on both state and the union of India can legislate. Thus, it is in the concurrent list. It's limited to ensure that the governance of state is not taken over by the union. Very important. This would completely abrogate the federal system of governance and the principle of representative democracy. It is with the objective in mind that the members of the Constituent Assembly thought it fit to limit the executive powers of the Union in a state over matters on which the state has legislative competence. In the spirit of cooperative federalism, Union of India must exercise its power within the boundaries created by the constitution. The union government cannot enter into other domain which they should not enter. Am I clear? Is that clear? So the Supreme Court further stated that Article 239AA, which says that Delhi will have a special status as the national capital territory of Delhi. It is said that it enhanced the representative form of government was incorporated in the constitution. Now, this article deals with the spirit of federalism with the aim that the resident of the capital city has a right to vote and choose their elected leader. It is the responsibility of the government of the state, NCT, to give expression to the will of the people of Delhi who elected it. Therefore, the ideal conclusion would be that greater National Capital Territory of Delhi, ought to have control over services subject to the exclusion of the services which are out of the legislative domain. So the state legislature will have every power other than land, police, public order. Moving on to the third important judgment. Animal Welfare Board of India versus Union of India, which dealt with Jallikattu issue, and the Supreme Court, a 5-judge bench of the Supreme Court, upheld the practice of Jallikattu. So what is Jallikattu? Jallikattu is a bull taming sport which happens during Pongal every year in the state of Tamil Nadu. So here is a particular sport wherein a bull is released into the crowd. Hundreds of people are there, and their attempt is to grab the hump of the bull with their hand, so that the bull fails and sits down. That's their aim, that's their objective. Now, people, a lot of animal right activists say that this is inhuman, this is, it's cruelty towards animals, and henceforth this case. Now, in 2014, a two-judge bench of the Supreme Court in Animal Welfare Board of India versus A. Nagaraj banned use of bulls in Jallikattu. It happened in 2014. So in 2014, the Supreme Court says Jallikattu using bulls is illegal and banned. In 2016, the Government of India passes a notification allowing the practice with certain restrictions. Government of India said, okay, the Supreme Court has banned, we will issue a notification wherein there will be, you can do Jallikattu event, but with certain restrictions relating to animal rights. In 2017, the Tamil Nadu government passed a law, Prevention of Cruelty to Animals Act, which permitted the sport, but introduced rules. There were certain restriction in this 2017 notification by the Tamil Nadu government also. So 2014, Supreme Court bans Jallikattu. 2016, Government of India says, okay, I'm allowing Jallikattu with certain restriction. 2017, the Tamil Nadu government comes out with an amendment relating to this practice of Jallikattu. Now, PETA, which is the People for Ethical Treatment of Animals, filed a petition challenging this Tamil Nadu amendment, which permitted the sport of Jallikattu and introduced certain rules to govern the sport of Jallikattu. Now, in 2018, a two-judge bench of the Supreme Court referred this matter to a five-judge bench. Now, what were the questions? Whether the sport of Jallikattu is protected as a cultural right under Article 29, whether the Tamil Nadu amendment is violative of Article 51 of the Indian Constitution, which talks about protecting the environment and development of scientific temper, as it is promoting bull taming sport. The third question was, does the Tamil Nadu legislature has the power to amend the Prevention of Cruelty to Animals Act 1960? And question number four was, is Jallikattu essential for the survival of and well-being of the native breed of bulls involved in the sport? So these were some of the questions that were referred to the five-judge bench. The Constitution bench, which was headed by Justice K.M. Joseph, right now he has retired, Justice Ajay Rastogi, right now again he has retired, upheld the practice of Jallikattu permitted by the 2017 amendment by the Tamil Nadu legislature. So the Supreme Court has upheld. Now the question is, why? Now the Supreme Court says that there are certain culture. Now there are bullfights, there is cockfight happening in Spain, there is something happening in Israel, there is something happening in somewhere Brazil. No, every country has certain cultural rights. Now people in Assam, people in Manipur, people in Arunachal Pradesh might have different culture. The manner in which a Bengali marriage takes place is very different from a Rajasthani marriage. So, and that's one of the reasons why B.R. Ambedkar protected cultural rights of every individual. Now, if there is a particular culture, I'm giving you an example. Kedarnath, on the opening day of the Kedarnath, पट बनता है, गोपीनाथ से पट लेके बाबा भोलेनाथ को केदारनाथ लेके जाते हैं. There are certain culture, okay, or some people are going to dance, some people are going to play this mantra, some people are going to put some garland on the deity, some people are going to झाड़ू देंगे रास्ते में before the pat comes. So there might be hundreds of culture attached to certain people. Now, do we have a right over that? Yes. India is a composite culture. Okay, our strength is in diversity. Some people, in Manipur might have certain animals which we don't eat. People in the northeastern state at times, there are things that, they eat dogs. Now, for us, how can you eat a dog? But for them, in their culture. So how does it matter? Okay, a Bengali will say, okay, I can eat fish. Somebody in North India will say, oh, how can you have fish? So there can be certain cultural difference, but we have to protect that. That was one of the most important intention of the Supreme Court. The Supreme Court said that we do not accept the view of Nagaraj that Jallikattu is not a part of cultural heritage of Tamil Nadu. Now, for example, Durga Puja has happened to be a cultural heritage of West Bengal. Now tomorrow you say no. During Durga Puja there is a lot of pollution. Cats, dogs, cows cannot roam freely in the street. Stop Durga Puja. Now you cannot get into that, right? We do not think that there was sufficient material for the court to come to that conclusion. When legislature has declared that Jallikattu is a part of cultural heritage of Tamil Nadu state, judiciary cannot take a different view. Legislature is best suited to decide what is the cultural heritage. Is that clear? And finally, the last important development, Arjun Ram Meghwal has been appointed as the Union Law Minister after Shri Kiran Rijiju was shifted to the Ministry of Earth and Science. So the previous Law Minister, I'm sure, was Kiran Rijiju. All of you are aware of it. As on today, he's taken over in the Ministry of Earth and Science, and Arjun Ram Meghwal has been appointed as a new Law Minister of India. Very, very important. Okay, but before we end, I hope you enjoyed it. So do press the like button. BYJU'S Exam Prep brings to you CLAT 2024 Essential What to Study and What to Skip live interactive workshop on 18th of June at 6 p.m. BYJU'S Exam Prep brings to you a CLAT 2024 comprehensive course wherein we are providing you with 300 plus hours of recorded videos, 500 hours of live classes, 35 mock tests for CLAT and other law exam along with video solution, monthly e-magazine for current affairs, and the content is based on our extensive analysis of the last 5 years of CLAT question paper. BYJU'S Exam Prep brings to you unlock your 3-day free trial access to all our courses. So guys, if you like today's session, do press the like button, do subscribe to our YouTube channel, do follow us on our Instagram, do like our Facebook page, do join our Telegram channel, and do not forget to download the BYJU'S Exam Prep app today. With this, we come to the end of this session. Thank you very, very much. God bless you. Stay home, stay safe, stay healthy. Have a great evening. Have a great week ahead. Till then, bye-bye. Take care. All the best.